Welcome to IDR Intel with me, Stephen Lawson. Estates are to be administered. A big part of our work here at IDR Law is when estates are not administered, perhaps because of delay, conflict, or broken relationships. And that area of work is increasing. We often see cases where it's 5 or 10 years since somebody has passed away and the estate administration has not been completed. Now, I did a talk with Ian Bond on our previous talk about some of the reasons for a delay. For example, when somebody puts a caveat and a grant cannot be obtained. But we wanted to look today at the other end of that scale, when a grant has been obtained, but for example, when it's not been possible to deal with the administration of the estate because, for example, the executors fall out or find themselves in a position of conflict. So I'm delighted today to be joined by Toby Bishop. Toby Bishop's a barrister at Five Stone Buildings. It's funny, if I refer to the legal directories, he's described as an incredibly safe pair of hands. So he's obviously who you need if there's an emergency. But on a serious level, he's described as an exceptionally good barrister and a very persuasive advocate. Now, I've worked with Toby for a good few years, and more than anything else, I find him to be a warm and personable, real person to deal with, always very friendly and very helpful. I also discovered just the other day he's a leading expert on the impact of the forfeiture rule, and he's probably done more cases about that than anybody else. But we're not going to talk today about that. We're going to talk about delay. So over to Toby. How have you been finding issues about executors and delay recently, Toby?
Well, there are quite a lot of claims and applications that arise out of it. I think it's partly the new or the modern information age, and the fact that people can find out information about assets, information about what it is that personal representatives and administrators ought to be doing, and can form a bit of a clearer view about whether or not the ones that they've got are doing it, and if not, what things can be done about it. So yeah, and of course we're coming into this era that people refer to as a sort of the transition of wealth kind of era, with the baby boomer generation becoming much older, and of course people, their children and their grandchildren being in circumstances where they can't themselves afford to buy houses, and so the money that people are inheriting is possibly more important to them now in terms of their quality of life and the security of their future than it's ever been before.
The bank of mum and dad is what I'm going to jump in and say there. People are always referring to that term these days, and I think you're reflecting that.
Yeah, that's right. And so people are more willing to call out, or more able to identify when things are going wrong, and more willing to try to do something about it, to move it along.
So are there issues, sort of common issues, that keep recurring in terms of the things that go wrong? What sort of problems cause the problems, if you like?
Yes. There's the sort of immediate problems that are the grounds that people make the application. So delay, allegations of conflict, allegations of potential or identification of potential conflicts, or just great difficulties in the relationship. But most of the problems, I think, begin long before that, and they're probably problems caused by sort of wishful thinking, really, on the part of the people who put these people in that position in the first place.
Yeah, I think we would reflect that. I was dealing with somebody only this morning. Mrs. Miggins appoints a friend to be the executor of her estate, but doesn't make her friend a beneficiary, and so she ends up with a whole headache. And then sadly, Mrs. Miggins's friend becomes unwell herself, and that's one of the things that can lead to delay. And so I think what we've not expressed, but what is probably very true, is care about the appointment of executors in the first place. One of the things that I know that solicitors or will preparers do is they'll take instructions, what's your name and address, etc. And an early question is, who do you want to be your executors? Now, they'll then go and take the full instructions. And I think then it's an ideal opportunity to say, well, yeah, why don't you think about appointing a professional executor? In other words, not putting forward that appointment in every case, but in every case where it's appropriate to do so. For example, if there's high value, if there's potential conflict. I mean, I want to share just a story. We had a testator who put a note with his will that said to his executors, who were a second wife and a son by a first marriage, I know you've never got on in my lifetime, but I hope you'll get on when I'm dead. Well, that court case is still going, because they absolutely hated each other. So I think I share your view about insights and trying to understand what is a foreseeable consequence. If you look back where there's a dispute, people might say, well, that was obvious, that was never going to work. But will preparers need to add value to what it is they're doing, perhaps by becoming more of a trusted advisor. So I'm with you on that, Toby, 100%.
Yeah.
But we've got other issues. Sorry, I was just going to say, you've got other issues of self-dealing and misappropriation and lifetime dealings and things as well. How common do you find those issues?
It's probably slightly less common than people suspect it to be, or the conflict and the sort of prefer when the fiduciary is preferring their own interests is, I think, a bit less common than the people who are accusing them of doing it think it is. And sometimes it's sort of, there's some posturing by the person in the fiduciary position before they then go and take some advice, and some sensible person then tells them, well, you can't do this, and then the posturing stops. But by then the relationship's already fractured and the trust has gone, and anything that person does after their siblings or their stepchildren or their stepbrothers or whatever are going to think that they're up to no good. And it's quite hard to get it back to some sort of proportionate resolution after that's happened. But there is a fair amount of it, because and part of that also comes from that sort of wishful thinking, and from it would usually be in most estates that I see, it would have been much better if a professional had been appointed at the beginning. But then I only see that fraction which have gone horribly wrong. And so I do agree with you that it's not always the right thing to do, particularly if it's fairly low value, or if what's being done is basically very straightforward. Sort of one family structure goes to the spouse and afterwards goes equally between the children. If you've got people falling out about that, you've probably got quite a wrong in there somewhere. So, but if it's not that, and many modern families are not that, are they? They involve second marriages or second and third marriages, and unequal numbers of stepchildren, and the nephew who worked very hard on the farm and that sort of thing. If you're not doing something that's entirely vanilla, quite often it's the testatrix or the testator who was the sort of glue that held the whole thing together. And it's probably quite hard to recognise that if you are that testator or testatrix. Everyone was muddling along because you were the matriarch or the patriarch, and either they felt obliged to muddle along, or just simply your sort of authority of personality, etc., caused them all to muddle along together. And once that person's gone, there's no longer a common interest. There is everyone out for themselves, which is, sounds quite mercenary and unattractive, but that is the way that it seems to be by the time it comes to a full-on dispute.
I think that's great insight, your phrase there about vanilla and glue that's holding things together, because that is indeed something that happens quite frequently. But another really common situation is where somebody who is appointed as executor, the favourite son or the favourite daughter, then they go and live or move into the testator's house either shortly before death or shortly after death, and then simply refuse to sell the property. That's a very common situation that we find, more common than we would want. And there the case is often that people either come to us or get referred to us 5 or 10 years on, and it can be quite shocking just looking at it from above, thinking, how has this been allowed to go on for so many years and nobody's done anything? And sometimes there are will preparers or solicitors still involved in the scene but aren't themselves very sure about what to do, or they're concerned about conflict, either between, if they're representing all the executors and one of them's living in the property, they sort of freeze and think, well, I can't really do anything hostile to that executor because I also represent the other executor. I'd better do nothing. And then it leads to an inertia, rather than saying perhaps to both executors, look, if you carry on like this, and some will preparers are doing this more frequently now, they are saying, look, we can't go on like this. There is a conflict. You're going to have to, if you can't sort it out, we'll have to stop acting for both of you, and you'll both have to get separate legal advice. And that's when things often open the door to a solution. But until the people dealing with the administration of the estate, the professionals, if you like, sometimes that could, and understandable problems, because it's not nice. It's not nice to say to people you've built up a relationship with, sorry, I can't act for you anymore, because clients are going to go bonkers at that, and they often do. And so, what do you mean you can't act for me? You've been my solicitor throughout, or whatever. But a conflict arises, and you've got other beneficiaries banging on the door, and they're the sort of typical problems that we see. And I suppose as well, there's other problems where one of the executors does think, oh, I'll go and buy that property myself. The self-dealing rule, Toby, I think that's perhaps quite misunderstood by some practitioners about what they can or can't let their clients do. Do you find self-dealing comes up?
Well, it does, and a big part of that is looking at the provisions of the will as well. Whether it incorporates the step provisions, or whether it's a sort of a bespoke set of provisions. That because quite often the case will come to one of us in a sort of purely litigation situation, and someone will say, well, that's self-dealing, so we can get them out, and possibly. But if they're authorized to do it in the will, and sometimes the testatrix or testator sort of wanted them to do it in some way, wanted them to sort of acquire it from the estate and buy out their siblings, and so it requires a bit more sort of bottoming out than it first appears. But I mean, I had one recently where the two personal representatives, two executors, jointly own the properties with the deceased, and they just decided that they were going to have them, and when it was explained to them that was probably not okay, then they decided they were going to have them at the price that they were going to set themselves. Also probably not okay, and so eventually they had to go. But it's probably also worth thinking about. I mean, we're not trundling through different paragraphs of different judgments, but what the kind of test is that somebody has to show, whether it's self-dealing, or whether it's that somebody has potentially taken some money that they shouldn't have taken, or muddled about with the administration in some other way. And it's not really, for removal, it's not a particularly high standard, because there's that run of cases between 2015 and 2019 with the Chief Master Marsh, as he then was, where he sought to sort of reframe this removal jurisdiction so that it didn't become totally disproportionate, and you're having multi-day trials about essentially how to just get the administration completed lawfully. And so that there's a couple of different ways of putting the test for that aspect of it, the sort of misconduct type aspect of it. But it's either that the people complaining show a good arguable case, or that there's a serious issue which requires further investigation. And of course, if there is, then the incumbent, the party with the cause of action is usually the estate, and so the incumbent can't be investigating themselves. And so they're in a way, they're the easier ones. If you can point to something that looks very much like some sort of misconduct, then in my experience of these applications, well, most of the time, somebody will be sensible about it. Somebody sensible will be brought in on behalf of the executor before it gets to a final hearing, or it gets to a final hearing and the judge removes them. The only time that sort of doesn't work is if it really is some trivial issue, or if for example everything else in the estate is done and there's just that question, and the court sometimes thinks, well, it might be easier for us, the court, to decide that question rather than to bring somebody else in and everybody else continue fighting about it, and then we still possibly have to have some sort of claim to decide that question anyway.
So I think what we're saying there is we're providing the solutions to the problems when there are delays. One of the solutions is self-evidently make an application to remove the PRs, but another solution is an application to seek a specific direction, for example, with regard to the sale of a property. So would you do that as a standalone type application that, Judge, here we are, order the sale of 1 Acacia Avenue to be sold with ABC estate agents at a price not less than £blank? Is that the sort of application that you would be making?
Yeah, well, I mean, it's dependent on the whole context, isn't it? Because if there's plenty of other things to do in the administration, and whatever the one thing that you might be applying for a direction about has caused a complete breakdown in the relationship, and these beneficiaries are not going to be able to agree about anything else, sometimes it is easier to bring in a sort of a new broom and have an independent professional who everybody might respect a little bit, who can just give some sensible views about all of the different things, and maybe people can then avoid some sort of full-blown litigation. But yeah, if it's a discrete issue and there's not much else to do in the administration of the estate, then sometimes the most proportionate thing is to just apply for the court to decide that discrete issue. I think, I mean, it tends to be, well, if you're the one who's going to be issuing the application, the main question is, what is a thing that you can issue and win? Because the worst thing for you is to issue something that you then don't win. I mean, because then you're paying everybody's costs, which is usually a worse outcome than having taken the hit on the original issue. So it's about winning, but and as far as the court's concerned, it's about pragmatism. That's the big buzzword from the Chief Master's decisions and what's been said afterwards. The court is interested in a pragmatic solution for whatever this problem is, and the party, if you like, the Chief Master described these sort of removal applications as not ordinary inter partes litigation, and that the court is concerned with the best interests of the beneficiaries as a whole. So it's not, you usually got sort of factions, and they may have uneven interests, and it might even be that that the court ends up having to do something different to what the dominant faction wants to happen, because it's just got this general discretion and supervisory jurisdiction. But if you can work out in advance what you think the most pragmatic way, pragmatic usually means cheapest and quickest, doesn't it? The cheapest and quickest way of getting this to a concluded administration where these people who've fallen out with each other don't have to talk to each other anymore if they don't want to, then the court will thank you for it. And that's essentially what the court's most likely to do. So yeah, it's whatever the route to that is.
So I think we've helped to identify the solutions there as well as the issues. I think what people need to do, whether they be beneficiaries or executors or PRs, if they get stuck, seek advice. Don't just sit and leave it, because if they do sit and leave it and just wait, then something probably more unpleasant is going to happen in terms of an application, either against the professionals if they're executors or PRs, or potentially a negligence claim. You didn't advise me that this would happen if I didn't do something. I find that quite often, unfortunately. The solicitors who are instructed by lay executors, and the solicitors don't give advice that they perhaps should have done, about the need. They'll say, my solicitor never told me that I had to do this, and that's sometimes a valid criticism. So we're always here to help. I know you help me a lot, Toby, when we get these sorts of problems, but I think the first step is for people to talk or ask the question, look, get an objective pair of eyes on this. Are we doing this right? It's not just removal, it's sometimes seeking a declaration from the court. Executors can go themselves, can't they, to court and say, what should I do? How should I resolve this? We've got one faction saying this and another saying that. What should we do? So as a last resort, if they really can't get a resolution, courts, I find, are often pragmatic and willing to help an executor to get through a difficult situation, because as you and I both started by saying, it can be an onerous task to be a personal representative, and courts will generally seek to help people who are doing their best in good faith in an appropriate and professional way. So Toby, thank you for your wisdom and insight. I think, as ever, our views reflect one another. Don't sit on a problem. Seek advice. There are always solutions, whether it be directions about properties, whether it be removal, or whether it be an order, for example, a direction to sell a property. So let's hope that people find this of use and that we can cut through delay and remember that estates are to be administered. Thank you very much for joining us, Toby.
Thanks, Steve.